I'm sorry firstly for being late. Yesterday my flight was supposed to reach here at 6:30 in Bagdogra. But sitting in the plane in Delhi, they told us that something is wrong with it. So we had to change aircraft. And by the time the plane took off and landed here at past 9 in the evening. And then I found out that your academy's driver is a pilot. He brought me in the shortest possible time, considering there were the trucks on the road. Night time you get your supplies, because in the daytime people travel. So that was an experience, and then I thought that I would like to have a look at what note I have prepared for you. Well, I didn't really get that opportunity. And I am not technically sound, so I'm depending on your people. I've given them a pen drive so that the note can be displayed somewhere and we can get on with our discussion. When your director invited me and told me that I am to address you on, I'm so glad that it's here. Constitutional status of trial judiciary, principles of natural justice for procedural fairness, speedy justice and fairness in trial, doctrine of precedent in the first session, and then application of the principles of administrative law in court management, special provisions relating to the state of Sikkim, Article 371F of the Constitution of India, discussion on the judgments of Honorable Supreme Court of India and High Court of Sikkim and its importance and implications to Sikkim. I was wondering, I was told that my audience will be the judges from the district judiciary. I was wondering the relevance of constitutional discussion, because the district judiciary is really essentially the courts which have contact with the public on controversial or contested matters on civil and criminal side. They are the trial courts. So then I sought a little clarification from the director, and he said that this is what the National Judicial Academy had concluded, that there should be discussion on. Still then, I was busy with my work in Allahabad High Court. There's a lot of pressure there. And I detailed one of my, or rather I have only one research assistant. She's a very resourceful person. So she prepared a topic-wise, point-wise paper for me. And then I began to understand the wisdom of the topics. So we will begin. Yeah, where is that note thing? Put it up here or somewhere? Yes. Justice Krishna wrote very beautiful prose and said many things which can be quoted. I have borrowed one. The trial court is the grassroots of justice delivery. If it fails, the whole edifice of justice collapses. Now we begin from here. Constitutional status of trial judiciary. This is the introduction. Around 4.6 crore cases as of 31st July 2025, we have just passed it, are pending in trial courts, which are the first point of contact for citizens. The Indian judicial system rests on the trial courts, and only a strong foundation can support a stronger and more efficient system of justice. In both civil and criminal cases, the trial judiciary is crucial for application of the rule of law. Now we go on to the constitutional status. The subordinate judiciary, that is how it's called in the Constitution. You see, the Constitution has terms. It has a chapter or a part of a chapter which deals with the subordinate judiciary. Now, we have had observations made by honorable judges of the Supreme Court saying that we should do away with calling the district judiciary the subordinate judiciary, and we should call it the subordinate judiciary. The district judiciary. My personal view is there is nothing wrong in being a subordinate judiciary. If I can share with you, today I am, as your director said, J3 in Allahabad. That means I put in a lot of time. There was a time when I was young. I was a junior. You have to be subordinate to become the High or the Supreme Court. Now, when there is an appeal is generally a statutory right. If a statute guides your rights and liabilities, you come and say, as you assert a right, the person who you are against whom you are asserting the right may say that I have a case in defense. So the court pronounces a judgment, and then the procedural law provides for an appeal, a prescribed time to appeal, whether any delay can be condoned. So you go on to the appellate stage. Now, the appeal court is a superior court. So there has to be a subordinate court, the lower court. The lower court record be called for. Why? Because at trial, the evidence is recorded before the trial court. But when you are in appeal, all that has been recorded in the trial court comes up before the appeal court as a continuation of the suit. And then the CPC provides that there can be production of additional evidence in appeal. But otherwise, it's the brief before the trial judge which is before the appellate court. So therefore the lower court. Now when, under Article 130, the Supreme Court is not an appellate court. It's the Supreme Court. Now the Constitution provides a right of appeal, not a right of appeal. The Constitution provides power to the Supreme Court to grant leave in a particular case for that matter to be treated as an appeal by the Supreme Court. Article 136. So the final court of appeal is the High Court. Now, if there is a judgment of the High Court, of a High Court, or any other court or tribunal, the Constitution says that the Supreme Court may grant leave and then itself become the appellate court in that matter. Now the appeal, once it becomes an appellate court, it is bound by the procedure of appeal in the CPC, subject to the rules it makes. The Supreme Court has its own rules regarding adjudication, procedural steps to be taken for the purpose of adjudication of an appeal in the Supreme Court. So when the Supreme Court is hearing an appeal from a judgment of the High Court is the lower court. The record of the High Court is to be called for as the record of the lower court. So one can only be junior and good at it to become a senior. You can't become straight directly. So the subordinate junior courts are the first entry-level courts where a litigant goes. Now, in order to achieve a separation of powers, Articles 233 to 235 seek to guarantee the judiciary's independence from the executive in accordance with Article 50. Let us see what Article 50 is. You all have books. Only the Constitution is necessary. I'll read it out to you. Article 50. Separation of judiciary from executive. The state shall take steps to separate the judiciary from the executive in the public services of the state. Now, this is an article that comes within the chapter of the directive principles. So this is something to be achieved. I think there have been steps taken, and we'd like to think that we are independent. But there is discussion and views taken and articles written in the papers, and nowadays you have the internet media, which is something different in addition to the print media. So there is lot of discussion and conversation as to whether there is independence or whether one is stepping into the domain of the other. Like the executive interfering in appointment of judges, because after there has been interpretation by the Supreme Court, the collegium system has developed. Now that's the law. Now there are recommendations made which are not acted upon. So that's one area where there is a little bit of discussion. Then on the other hand, the Supreme Court went and gave an interpretation of what a governor can do or cannot do in respect of a bill that is passed in the Legislative Assembly. Now that is also something that some people say is judicial overreach, while others say it was necessary because the governor was sitting on the bill. And then you have the reference made by the President of 14 questions. So you see, this is always there because we are trying to achieve a separation. And whether it has been achieved or not is always open to discussion. Then we have this case, Chandra Mohan versus State of UP, reported in AIR 1966, Supreme Court 1987. I have taken out two paragraphs I want to read for you. Paragraph 7 first. The first question turns upon the provisions of Article 233 of the Constitution. Then Article 233 has been set out in the judgment itself. Appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. Now the Supreme Court goes on to say, after quoting the article, we are assuming for the purpose of these appeals that the governor under Article 233 shall act on the advice of the ministers. So the expression governor used in the judgment means governor acting on the advice of the ministers. The constitutional mandate is clear. The exercise of the power of appointment by the governor is conditioned by his consultation with the High Court. That is to say, he can only appoint a person to the post of district judge in consultation with the High Court. The object of consultation is apparent. The High Court is expected to know better than the governor in regard to the suitability or otherwise of a person belonging either to the judicial service or to the bar to be appointed as a district judge. Therefore, a duty is enjoined on the governor to make the appointment in consultation with a body which is the appropriate authority to give advice to him. This mandate can be disobeyed by the governor in two ways, namely, one, by not consulting the High Court at all, and two, by consulting the High Court and also other persons. In one case, he directly infringes the mandate of the Constitution, and in the other, he indirectly does so. For his mind may be influenced by other persons not entitled to advise him. That this constitutional mandate has both a negative and positive significance is made clear by the provisions of the Constitution. Wherever the Constitution intended to provide more than one consultant, it has said, see Articles 124, Sub-Article 2 and Article 217, Sub-Article 1. Wherever the Constitution provided for consultation of a single body or individual, it said so, and see Articles 222 and Article 124.2. Goes further and makes a distinction between persons who shall be consulted and persons who may be consulted. These provisions indicate that the duty to consult is so integrated with the exercise of the power that the power can be exercised only in consultation with the person or persons designated therein. To state it differently, if A is empowered to appoint B in consultation with C, he will not be exercising the power in the manner prescribed if he appoints B in consultation with C and D. And then paragraph 14 for you. Before construing the said provisions, it should be remembered that the fundamental rule of interpretation is the same whether one construes the provisions of the Constitution or an Act of Parliament, namely, that the court will have to find out the expressed intention from the words of the Constitution or the Act, as the case may be. But if, however, two constructions are possible, then the court must adopt that which will ensure smooth and harmonious working of the Constitution and eschew the other which will lead to absurdity or give rise to practical inconvenience or make well-established provisions of existing law nugatory. The Indian Constitution, though it does not accept the strict doctrine of separation of powers, provides for an independent judiciary in the states. It constitutes a high court for each state, prescribes institutional conditions of service of the judges thereof, confers extensive jurisdiction on it to issue writs, to keep all tribunals, including in appropriate cases the governments, within bounds, and gives it to the power of superintendence over all courts and tribunals in the territory over which it has jurisdiction. But the makers of the Constitution also realized that it is the subordinate judiciary in India who are brought most closely into contact with the people. And it is no less important, perhaps indeed even more important, that their independence should be placed beyond question in the case of these superior judges. Presumably, to secure the independence of the judiciary from the executive, the Constitution introduced a group of articles in Chapter 6 of Part 6 under heading Subordinate Courts. But at the time the Constitution was made, in most of the states the magistracy was under the direct control of the executive. Indeed, it is common knowledge that in pre-independence India there was a strong agitation that the judiciary should be separated from the executive, and that the agitation was based upon the assumption that unless they were separated, the independence of the judiciary at the lower levels would be a mockery. So Article 50 of the Directive Principles of Policy states that the state shall take steps to separate the judiciary from the executive in the public services of the state. Simply stated, it means that there shall be a separate judicial service free from executive control. So therefore, the district judges of the district judiciary have their superintendence or control vested in the High Court. Now that's for the purpose of administration. There is this administrative side and the judicial side. So like the executive decides on how to administer and what to do, we also have our administrative side. So therefore the district judges, they have their own budgets. And the Chief Justice of the Calcutta High Court, Chief Justice of the High Court likewise has the budget for the judiciary in the state. So on a lighter side, I have come around to think that a district judge's position is better than a puisne judge of the High Court. So we have district judges here. District judges?
Yes.
Yes, you agree. So you are the district that you have, you are the last one. You decide. Nothing happens without you knowing. So far as puisne judges are concerned, they are confined to their rosters. And they may be portfolio holders over a district. So when they visit the district, they get a lot of flowers and yes. Now you see, I'll give you an example. The Supreme Court, while dealing with a criminal case, was affected by the delay. There had been an order of stay passed by the High Court, and thereafter the matter was not adjudicated. There were adjournments taken. State was prosecution. They didn't do anything about it. So, while dealing with that matter, the Supreme Court gave a direction, some Asian resurfacing or something the case name was, gave a direction that after 6 months, the higher court stay will automatically be deemed to be vacated. Now they came to be a second Asian resurfacing case. Now why this happened? The High Court has control over the district judiciary. The district judge or the judge in the district judiciary had in front of him a stay order. Stay desist. Stay order in front of his eyes or her eyes. I think it was a he. And in spite of the judgment of the Supreme Court of automatic vacation of the stay order, he thought my service book is with the High Court. I better obey the High Court's order. So they came to be the second resurfacing case. And then the Allahabad High Court, the Bar Association of Allahabad, they raised a few points. And a larger bench in the Allahabad High Court decided to ask the Supreme Court to elaborate on these judgments. And the Allahabad Bar Association, High Court Bar Association then came to be a matter in which the Supreme Court again deliberated on Asian resurfacing and said it creates problems and gave interpretation of powers of the Supreme Court under Article 142. They said that that power is case specific to complete justice. So it may be something that law at present does not provide for, but exercise of power by Supreme Court under Article 142 means the directive, the decree is to be enforced anywhere in India. Because the Supreme Court is not a trial court. It's the Supreme Court. It's sitting in appeal. Now it passes an order. It becomes a decree. It is to be enforced anywhere in India. Now look at that, if we can digress for a moment. Enforceability of decree goes by territorial jurisdiction. Then you have to transmit a decree if it is to be enforced somewhere else. These are all CPC provisions. So that is why Article 142 says that once the Supreme Court passes an order under Article 142, because it is doing complete justice in a case, it is to be enforced as a decree anywhere in India. That's the article, that's the purpose of it. The thing is, the most relatable exercise of power under 142 would be for the Supreme Court to dissolve a marriage. Now you have, at least if we take the Hindu Marriage Act, you have section 13 providing for grounds of dissolution of marriage. Now that's a procedure that is to be executed for purpose of contest and adjudication. Either of the spouse says the other is bad, and the other spouse may raise a counterclaim, and the court can either pass a decree of divorce, dissolving the marriage, may give alternative relief of judicial separation. All these are things that happen under when the power under the section 13 provision is invoked. Now section 13 is very clear. Cruelty, desertion, and all the other grounds that are there. You have to prove it to the hilt. At least in the civil side, preponderance of probabilities. There is no other way out. But you look at 13b, the two parties can agree. If they have stayed separately for a year, they can file jointly. And then the legislature has thought that there should be a cooling period of 6 months, so that in event they change their mind, and if they still stick to their positions respective, and they still agree to go their separate ways on whatever terms they have agreed, the court will pass a decree. Now these are the two distinct. One is by consent, one is by mutual. Two distinct. And in none of these two provisions, irretrievable breakdown of marriage is a ground. You will find many judgments of the Supreme Court dissolving marriages on irretrievable breakdown of marriage. Article 142. To be enforced as a decree anywhere in India. But for those two parties. No precedent. Case specific. As opposed to Article 141. So therefore in Allahabad Bar Association case, the Supreme Court reiterated that Article 142 is case specific. When you are doing a criminal case and you are angry that the case has been languishing, there was no adjudication, passing an order saying all stay orders are to be vacated after 6 months is not case specific. Have I been able to make the distinction between 140? But we are digressing. Let's come back. Article 233 deals with appointment of district judges and was also considered by the Supreme Court in state of Bihar versus Balmukund Shah, reported in 2000, volume 4, SCC 640, relying upon, amongst others, this same Chandramohan case. It was held that Article 233 enacts a complete code for the purpose of appointment of district judges, and consultation with the High Courts is an inevitable feature of Article 233. On independence of the judiciary, paragraph 75, let's see what it says. The hallmark of the constitutional scheme in the country is the role of judicial review assigned to the courts. Unlike the United States, our Constitution explicitly empowers the Supreme Court and the High Courts to check the actions of the executive and the legislature in case of such actions being incompatible with the Constitution. To ensure the existence of an independent, effective and vibrant judiciary, provision is made in the Constitution in Part 5, Chapter 4, dealing with the Union Judiciary, Part 6, Chapter 5, dealing with the High Courts, and in the states, and Chapter 6, dealing with subordinate courts. This court in various decisions has highlighted the importance of insulating the judiciary from executive interference to make it effectively independent. Then Article 233A deals with validation. Article 234 says recruitment of other persons than district judges to the judicial service. Again, state of Bihar versus Balmukund Shah, it was held that Article 234 is not made subject to laws made by the legislature, which means that the legislature cannot make any law regulating the appointment to the subordinate judiciary. This is the execution of the principle of separation. So therefore, you see now we come back to another situation where, you must forgive me for digressing. The states conduct their own selection process for appointing judicial officers, the high courts of the states. It's completely independent. Unlike the executive, the administrative service or the police service or the foreign service, it's all UPSC, Union Public Service. But so far as the judiciary is concerned, the high courts, they conduct independently their recruitment drives and they have their own procedure. The questions are set either outsourced from a university, law university, or the judges themselves set it, whatever it is, it's your own procedure. And there is movement for that to become a centralized selection process. You see, this is a fallout. The conflict, whenever you have human mind, it will have so many thoughts. So there is going to be argument and discussion. So your one thing is that you must be independent and there cannot be any control, cannot be any legislation. Now, if you are going to have a common entrance exam for becoming judicial officers, will it or will it not be entry of the executive into the process? So nothing settled, but there is this pull and push. There are pros and cons. We have such wonderful officers who are administrative officers. You look at them, the police officers. And I always think that the district magistrate's bungalow is better than the district judge's bungalow. Will you bear me out? So you see, why? Because the courts are not for revenue. We are not revenue collecting institution. But that doesn't mean that we get some fund from the state. They are doing us a favor. The Constitution says that we are to be separate. We are to be independent. If you want to call yourself a democracy, you've got to have a judiciary. Somebody's got to say that you did wrong. And we may be wrong in saying you're wrong, but somebody has to say so. The thing is, we look at what is before us, we apply our mind, and with honesty of purpose, we try to settle a dispute between people and institutions. So there is no absolute truth. The first court, trial court, passes a judgment. One of the parties are agreed. They go to the next higher court. If it's a judge of the civil division level, then the appeal lies to the district judge. Now that's the first appellate stage done. After that, one party or the same party is still agreed. Second appeal, High Court. Again, somebody is agreed. You can go to the Supreme Court. Now the Supreme Court ultimately, when decides on a matter which reaches it after having there been an original decree, first appeal, second appeal, then Supreme Court fourth level. Now the Supreme Court at that stage may pass a judgment. There's going to be a question of law involved because second appeal is question of law. So Supreme Court is going to settle some question of law. Now it may be upholding the decision of the trial court, or it may be upholding the decision of the district court. Depends on which way it went. Is that the last word? In a different case, the Supreme Court might constitute a larger bench and look at that same point again. So, there is no absolute truth you cannot say. Doctrines, principles, they evolve. They over a period of time, they evolve with the application into practical legal matters, things evolve. And let's come back. Paragraph 66 of Balmukund It would be appropriate to notice at this stage that while in Articles 145, Subarticle 1, 148, Subarticle 5, 187, Subarticle 3, 229, Subarticle 2, 283, Subarticle 1 and 2, the Constitution itself makes the provision subject to the provisions of law made by the Parliament. But Article 234 is not subject to any legislation to be made by the appropriate legislature. You see how the founding fathers, they did what they did. Which indicates that so far as recruitment to the judicial service is concerned, which is engrafted in Article 234, the same is paramount, and the power of the legislature to make law under Article 309 will not extend to make a law in relation to recruitment, though in relation to other conditions of service of such judicial officers, the appropriate legislature can make a law. So now, to what extent do we have the executive having a say? A state judiciary requires setting up of a new court. The executive asks for justification. Then a post has to be created. All this is part of the executive. But who is going to be appointed as a judicial officer? Clearly with the judiciary. You see the distinction. This is what it is. Article 235 deals with control over subordinate courts, which shall be vested in the High Courts. The High Court of Judicature of Rajasthan versus Ramesh Chand Paliwal, reported in 1998, Volume 3, SEC 72. It was held that the word control is used in a comprehensive sense to include general superintendence of the working of the subordinate courts, disciplinary control over the presiding officers of the subordinate courts, recommendation of imposition of punishment, including suspension for the purposes of a disciplinary inquiry, transfer, confirmation and promotion. Paragraph 34 and 36 are to be seen. Paragraph 34. This Article 235 shows that the High Court has to exercise its administrative, judicial and disciplinary control over the members of the judicial services of the state. The word control referred to in this article is used in a comprehensive sense to include general superintendence of the working of the subordinate courts, disciplinary control over the presiding officers of the subordinate courts, and to recommend the imposition of punishment of dismissal, removal and reduction in rank or compulsory retirement. Control would also include suspension of a member of the judicial service for purposes of holding a discretionary inquiry, transfer, confirmation and promotion. In state of Gujarat versus Ramesh Chandra Mashruwala, it was held that control in Article 235 means exclusive and not dual control. And paragraph 36, what is therefore of significance is that although in Article 235 the word High Court has been used, in Article 229 the word Chief Justice has been used. The Constitution therefore treats them as two separate entities, inasmuch as control over subordinate courts vests in the High Court, but High Court administration vests in the Chief Justice. Now, to bring home Article 229, your director, the Registrar General, these are all officers appointed by the Chief Justice in exercise of power under Article 229. And Article 235 vests in the court, as in the full court. So, the Chief Justice is an institution by himself or herself, the office. I was acting Chief Justice for a while, and I found out it's a lot of work, and I'd say let someone else do it. I'd rather come and spend some time with you. All right. Then Articles 236, 237, not much to be said about it. A passage I have referred to, All India Judges Association, the third case versus Union of India, 2002, Volume 4, SEC 247, Paragraph 27, a passage. The subordinate judiciary is the foundation of the edifice of the judicial system. It is therefore imperative, like any other foundation, that it should become as strong as possible. The weight on the judicial system essentially rests on the subordinate judiciary. Now, this is something that you must, if I can say, embrace, because you are the first contact with the litigant public. Now, personally again, I do not think that the court should be taken to the people. If A and B cannot resolve their problem, then they will find their way to court, is my thinking. Court is not a product. Adjudication is not a product that you will sell. That I am here, please come, I will settle for you. It is only when things get beyond the reach of the disputing parties that they may decide to come to court. Settlement is always best. This has ended up in a huge backlog. The judge to litigant ratio is bad. So now what are we doing? We are having alternate dispute resolution. We are encouraging parties to go for arbitration. Have we really been able to solve the problem? Is there an alternative to court? What is happening in arbitration? A has a problem. It has, let's say, supplied goods to B, and B has not paid for the goods. It has taken a defense on quality, rejection, money has not been paid, there is an additional claim of interest. It becomes a complicated dispute. Now when the buying-selling agreement is made, they add a paragraph, their respective lawyers do. Kya paragraph? If we have a dispute, we will go to an arbitrator. We will not go to court. Arbitration agreement comes into being. Now they have a dispute. If two parties have a dispute and they went to court, the civil procedure tries to see that every opportunity is given for a proper adjudication, assertion and defense. You go for arbitration. First round of litigation. Is there an arbitration agreement on appointment of arbitrator? It was first an administrative action. A request was to be made to the Chief Justice to appoint an arbitrator. An administrative act of the Chief Justice in appointing someone. It became a judicial act. So the first round you spent, do you have an agreement? Are you entitled to have arbitration? That is the first time. You know you got nowhere near the dispute. You are on whether there is an arbitration. And you can't go to court. Because you have decided you will not go to court. So you see, this is what is happening. Nobody can sell to me the idea that there can be any alternative to court. And you are the court of the first level. Take pride in what you do. Don't think of all these things subordinate law. You are the person who has been chosen to adjudicate someone else's dispute. It's a very special thing that you have got for yourself. There is no alternative to a court, if you ask me. Because the parties settle. That's their wisdom. The court or an adjudicator has nothing to do with it. To adjudicate, to analyze what somebody is asking, to counter it with the defense, and then come to a finding to the best of one's ability, is something that you must do well, and nobody else can do. And we have the benefit of being able to make a mistake, or being wrong, or being told by a superior forum that you are wrong. We are not doctors. If you are a doctor, what happens? If a person is to has some ailment, himself or herself or somebody in the family, what do those persons do? They get several opinions at the first instance and then they decide on a course of action. So that's different. So far as disputes are concerned, you first have a first round, then you have appeal. Interestingly, Sikkimese people don't need to pay income tax. Now, income tax is something that is assessed by the assessing officer. Now look at the hierarchy. The assessing officer, he is both an investigator as well as an adjudicator. He investigates. Have you suppressed anything in your return? And then after he gets your, however you have presented your case that this is the taxable income I have, so therefore you are going to tax it on that basis. Then he adjudicates. Has the return been filed correctly? Investigator, adjudicator, he passes an order. On top of him is the commissioner. First appeal. On top of that is the tribunal. Second appeal. On top of that is the High Court. Special jurisdiction. On top of that is the Supreme Court. So you see, whole thing is to read, understand the law and apply it to the best of your ability in analyzing the facts, the assertion and the counter. It's something that you will develop skill in doing. And if you are able to briefly record the facts, and facts are that which you come to believe are true, only then they can be fact. Otherwise it's an allegation. So if you can correctly come to the facts, thereafter your decision and entire thing briefly written, nobody can touch it. Because if over you, the superior court wants to overturn such a judgment that you've written, applying your mind, getting the facts together and applying the law, you will write a judgment of maybe 3-4 pages maximum. To overturn you, 30 pages have to be written. Do not go in for lengthy judgments. That much more scope for you to make an error. Do not comment on something that is not directly involved on the list. Do not exhibit your knowledge. Keep a restraint on yourself. Be a lawyer. You can win a case by not saying anything. I had a situation in Calcutta High Court when I was very nervous because my senior was sitting and I had the brief. So I argued, or rather the case went on and I also made an argument. I was lucky, or rather I won. My client got the relief. Evening when I went to the chamber, my senior told me, why did you open your mouth? The court was in your favor. Apply that. Be a lawyer. I have not stopped being one. Of course, I don't get to say so many things when I'm sitting as a judge. I am told so many things, I have to keep quiet and listen. You've given me an opportunity to come and tell you things. But that's how it is. You think of your position and direct your mind. And get to the facts. Once you establish in your mind what are the facts, the rest of it is going to be easy. The law is there. Figure. Now I talked about income tax. Income tax is an area of law where there is very little fact. It's all about law. You see, the government wants to be your business in profit. You will do some work, earn money, government wants a share. That's tax. How the show will run? Itna bada academy kaise banayenge? So they need to have revenue. So they try to make a net. And they will not let you slip through. and your income tax advisor and the income tax lawyer, they will find a way to wriggle through. So it's a matter of the mind. So that's a very interesting subject. Indirect taxes are not. Direct tax, which you are not concerned with because you don't pay. All right, let's go to the next one. Principles of natural justice and procedural fairness. Before we go, what's the time? You are going to accommodate, session is a period for you to wake up. Charge your mind. This guy actually doesn't know anything. Let's ask him a question to find out. Hai koi prashn? The law students? Who are the law students here? Only one. There you go. So many of you. You're going to become masters of law. हम तो BA है, bachelor. Fire away. Question? You are?
Just have a question, sir.
Yes, you have a question. I'm already scared.
Good afternoon, sir.
Teacher of the university.
Acha.
Dr. Naveen Sinha, Associate Professor here, SNLU. So my question pertains to the recent NCRB report.
Recent?
NCRB report, the National Crime Records Bureau report, according to which overcrowding in the prisons in India is around 140%, which means almost 97% of the prisoners in the prisons in India are under trial prisoners. And of these under trial prisoners, I notice around 50% of those prisoners are those who have been charge sheeted. That means
Charge sheeted?
Yes, ma'am. Yes, sir. So that means there's no option of default bill available to them. So my question is, it pertains to plea bargaining. So can plea bargaining be used as a useful method here to reduce the number of under trial prisoners in India? This is the first question. Or do you think plea bargaining is underutilized in India? This is my question. Thank you very much.
So, I have been trying to tell you about adjudication, and you are asking me a question for a way out. Plea bargaining means what? If a plea is accepted, if a person who is under arrest or who is accused of having done something, the prosecution takes the easy way out, is not able to prove to the hilt. Why? Because plea bargaining, there has been a negotiation where the accused has been told that if you accept the lesser sentence, then we will not go for the harsher one. What is not told is that I will not be able to prove anything. It's all negotiation. So this is something that happens which does not involve the judge. Now we are in a situation where we are talking about adjudication, either to seek adjudication or to do adjudication. As a lawyer, you will want adjudication and try to persuade the judge to your point of view. As a judge, you have to look at both sides. So the plea bargain thing doesn't really come within the domain of involvement of the court or the lawyer. Of course, the lawyer might still get his fee for not doing any work. So you see, I am trying to advocate application of mind, preparation of case and adjudication. Plea bargaining is again like arbitration or mediation, conciliation. Why settle? The first thing I gave answer is that the prosecution agrees on a premise that if you don't agree, I'll go for the harsher sentence. What is not told is, I will not be able to prove anything. So, plea bargaining again is something that will reduce pendency. And so far as overcrowding of jails is concerned, we have different perceptions at different levels. The magistrate on the ground, the High Court in its seat, principle or otherwise, and the Supreme Court in Delhi have different perspectives, has been my experience. On the ground, a judge at the first instance may not grant bail. By the time it reaches the High Court, you see then again there is the criminal procedure. What happens? There is anticipatory bail and there is bail. In bail also there is concurrency. You can apply for bail before the district judge, you can apply for bail before the High Court. So you see, at the first instance they go to the first available court, CJM's court, for bail. I am not too sound on criminal. Which is the first court they go. They can go to the High Court straight away, but they do go to. Now on the ground the perception is generally the offence or the accusation is nearer to home. There is tendency of rejection. Now this rejection, if there is on the opposite side grant of bail, the High Court on the administrative side questions, this judicial officer, why is he granting so much bail? Is he looking at the facts? Case diary dekha kya? Now when such a case ultimately goes to the Supreme Court, by that time incarceration has been for a long time. Supreme Court espouses the law, freedom, bail is the rule. But that's removed, that's not on the ground. So the perceptions differ, the practicalities differ. And if you look at bail, the investigation is undergoing custodial interrogation. That is why he is under arrest. So at that stage you cannot say very much also. But the tendency of litigation and the opportunities of approaching the higher court have become easier or more available, which is why all these things are happening. The criminal procedure code and the bail provisions are there. The wisdom of the legislature in making those provisions and requiring those provisions to be urged before a judicial officer, I think are quite sound. A policeman brings an accused to the court and says that the public prosecutor or the government advocate says no, bail should not be granted. In fact, if you look at the NDPS Act, if you think that you are going to give bail, you have to record your reasons that why he is not involved. That means bail is no. So look at the trend of the legislation. Trend of the legislation, you look at the NIA, NSA, National Security Act. NDPS and National Security Act, they both have provisions for preventive detention. You don't need to be accused of a crime, or rather you have committed a lot of crimes and you have been arrested in all of those crimes, you got bail in all of those crimes, then the government puts you behind bars, prevents you. Provisions are there in NDPS, in National Security Act. And what is the requirement? You have to refer it to an advisory board to get confirmation. And the advisory board usually includes judges, sitting or retired. But then it's subjective satisfaction. We are digressing. Any other question? Mike.
Good morning to everyone
Yes.
present here and good morning to Lordship. My name is Hon'ble and I am Assistant Professor of Sikkim National Law University. I'm not asking any question, rather I would like to know your point of view regarding the independence of judiciary in appointment of subordinate judges. So while we all know that judicial independence in the appointment of subordinate judges is basically aims to prevent executive interference. However, at the same time, sometimes we face some potential disadvantages related to this particular rule is that sometimes it lacks accountability and sometimes there is an appointment related to there is lack of transparency in while appointing those judges, and sometimes the recent terms which we use is that sometimes the nepotism is being used while appointing some kind of judge, subordinate judges. So because of this thing, there is certain leading to the disappointment that some kind of potential talents are being undermining in the country. So I would like to know your point of view regarding this particular matter, that how we should overcome such kind of disadvantages that is being faced by some talent in our country. Thank you so much, sir.
The thing is that we all very. Fact is, it doesn't always happen. Now, nepotism and getting to know the person who matters and who will do something for you has always been there. The system is trying to be sanitized such that only the best get there. I will try and answer your question, but before that I'll tell you something. When I became a judge, this exercise the executive wanted to do, that there is a lot of nepotism in this opaque system of appointment of judges by the collegium system. So we'll bring in the National Judicial Accountability Commission or something like that, NJAC. So that matter was pending before the Supreme Court at that time. So I have a lot of warrants because I became an additional judge. The system didn't know which way things were going to go, whether it will become NJAC or whether the collegium will continue. So I was, and we were appointed together, we got additional judge and we got extensions. So ultimately they thought that they will not let me go only in 2016. Till then I could have resigned and got back to arguing before the judges. And I even thought I would, but I didn't. So my senior in the bench, he told me, collegium means what? In the High Court level, the Chief Justice in advisement of his two senior-most judges, J1 and J2. So this is collegium at the High Court level. At the Supreme Court level, it's those three and plus two. Three for some matters and for more important like Supreme Court appointment, High Court Chief Justice appointment, 5. Otherwise 3. So he said, let's start with 3. Somebody wants to become a judge, he has to try and get his case moved individually to 3 persons. Mithai bhejna hai, do whatever you want to do. There are 3 persons involved. NJAC, if it becomes, what will happen? Those 3 will become 5. You've got to buy some more sweets. So that's the bottom line. We are human beings, human nature. People, there is a lot in lobbying. States indulge in it as a state. So individuals will. कौन किसको पहचानते हैं? How to get ahead. In a game of football, you mark your man. You see, it's always there. But I will also say this for merit. Because you see what happened. We have the reservation here. So those who don't get seats, what do? And even those who do get seats in the general category, if you get, at least when I was young, if you get a seat in an IIT, straight away you have stars and stripes in your eyes. Engineering karenge, US jayenge. What was our biggest export? Engineers. So you see, the merit always has avenue. So it is only the unmeritorious who try and get appointments in these ways. So don't confine yourself to looking to be appointed where you have to apply grease. Do something on your own. That way you get forward. You see, there have been occasions when I never thought I'll be a service person because I started in the bar. Nobody knew me. A judge who had seen me yesterday, today he refused to recognize me. That's the kind of practice I've been through. A case who nobody will do was brought to me. That too the client doesn't have the means to pay. Now from this, and a senior, she knows my senior, Bimal Chatterjee. I was with him because I had nowhere else to go. Otherwise I would have left him. Now that's the kind of background that I come from. The moment I started making a mark and the judge saw that, hey, this guy is saying something which is very difficult to deal with, so let's agree with him, they told me, hey, you come this side. Chalao, this side. So, you see, that is how I came this side. Now, after having come this side, I got into the office politics. What happens in the bar? Anybody, oh no, there are no practitioners here. Anybody in the judiciary who's come from practice? What happens in the bar? A client comes, gives you a case and says, I want to file a case against the defendant. So you write a plaint, you draw a plaint. You have to file the plaint, then the plaint will invite a written statement. So I as a junior draw a plaint. My senior looks at it, he puts it in the dustbin. And he drafts it himself. I look at it and I learn. Then I become judge. My senior is there. He gives the judgment. He has loads of experience. I think, I am a judge. The CPC allows. I will write a dissenting judgment. You see the difference? You see the difference? So once you get into a system, you have to fall into the system and you cannot say otherwise. I have said otherwise. So I've gone to Orissa, I've gone to Allahabad, and I'm waiting to go to some South Indian court. Oh, Allahabad nahi dekha. I have not seen South. I'd like to be a judge for a while till my time is there. Maybe in Kerala or somewhere. Lakshadweep sunechi khub. It's quite nice. Kerala judge, if I become, I can go, and then anybody who knows me can also go. So take an even strain. Don't let anything affect you. That's the answer. Okay? Let's proceed. Principles of natural justice for procedural fairness. Now all this, I think everybody knows. Basically there are there's so many toffees, I'm having one.
It's all for you, my lord. It's all for you.
Acha, I want to put it to you that we have so many topics that are there. You all have this paper, the schedule. All of you have the schedule.
Yes.
Now we have only covered the first bullet point. So I am seeking your suggestion as to which one we should do next. Any of them, whichever, because I think we're going to run out of time. So, any suggestions?
Yes, sir.
Do all of you have a book or can share? Constitution? Let us first look at 371. You will find that Article 371 was in its entirety substituted by Constitution 7th Amendment Act 1956. 371 itself it was substituted. So there was a provision which came to be substituted by this. 371 by Constitution 7th Amendment Act of 1956. This book does not have the original article, but 371 came to be, the substituted provision came to be a special provision in respect of two states, Maharashtra and Gujarat. So from there, we have had very many amendments to our constitution, in excess of 100 amendments. Now, that might sort of give support to the description of this constitution being a living document, because it's being added to as we get on with life. Now, the constitution was, our founding fathers, they studied several existing constitutions at that time, and keeping in mind and being the best persons to be consulted, as we've already seen what is consultation. They, the founding fathers, were the best persons to be consulted for the purpose of giving ourselves a constitution. So they looked at all the constitutions that were available at that time, and they had special knowledge about the people of India. If you look at the Constitution of the Constituent Assembly, you will find that there was representation of good minds from various, from the diverse communities of India. Now they made that constitution. Now after that there have been so many amendments to it. Now this special provision substitution came to be in respect of two states. So this was a pointer that whenever you need special provision of states, it naturally then came after or as additions to this article. So A, B, C, D, E, F, and F is for Sikkim. So how to read a statute? This is how it, this is the way the cookie crumbles, if I might say so. Okay? So we then come to 371F. Special provisions with respect to the state of Sikkim. Now, a basic idea I have tried to call out for you in my note. Yes, topic 6, all right. To start with, I am reading what I prepared for you. Article 371F of the Constitution provides specific provisions for the state of Sikkim, acknowledging its distinct requirements and historical context. Its importance is in granting autonomy, while guaranteeing a seamless transition into the Indian Union following Sikkim's merger in year 1975. This is the 50th year, I think you have just celebrated. Sikkim's distinct political and cultural trajectory has shaped its history, which is unlike that of any other Indian state. The Chogyal dynasty had ruled Sikkim, an independent state, for centuries until year 1975. A historic referendum was held in year 1975 and Sikkim citizens chose to integrate with India. As a result, Sikkim's history underwent a significant change, moving from monarchy to become a part of democratic India. Through the 36th Constitutional Amendment Act 1975, the Indian government included Article 371F to ensure Sikkim's seamless integration into India and to address the concerns of its citizens. This unique clause was thoughtfully written to safeguard the Sikkimese people's socio-political and cultural interests, while enabling them to establish a position for themselves within India's larger constitutional network, a framework. An essential safeguard is provided by Article 371F, which guarantees that Sikkim's distinct character, customs and administrative procedures are upheld and maintained even under the framework of the Indian state. Article 371A provides elaborately in respect of the state of Sikkim, role of governor. Special responsibility for peace and an equitable arrangement for ensuring the social and economic advancement of different sections of the population of Sikkim. And governor in discharge of his special responsibility under this clause, subject to such directions as the President may from time to time deem fit to issue, act in his discretion. The governor has wide discretion in matters concerning the citizens of Sikkim, in his being the governor, the first citizen of the state. Legislature. The Legislative Assembly of Sikkim shall consist of not less than 30 members. Special provisions were made for reservation of seats in the Assembly for different sections of Sikkim's population to maintain their political representation. The state of Sikkim is given one seat in the Lok Sabha and one seat in the Rajya Sabha. Applicability of laws. All the laws in force immediately before the appointed day in the territories comprised in the state of Sikkim or any part thereof shall continue to be in force therein until amended or repealed by a competent legislature or other competent authority. To ensure that Sikkim's pre-merger laws are compatible with the Constitution, the President may within 2 years of the merger adapt, amend or repeal such laws as necessary. Any changes made under this power cannot be challenged in court. I am concerned. आपका डायरेक्टर बोला controversial topic. The rest of India is very glad that Sikkim became a part of it. If the feeling is not reciprocated, we shall be very sad. Property and assets. All property and assets, whether within or outside the territories comprised in the state of Sikkim, which immediately before the appointed day were vested in the government of Sikkim or any other authority or any other person for the purposes of the government of Sikkim, shall, as from the appointed day, vest in the government of the state of Sikkim. So that means governmental property, property belonging to authorities, and property belonging to any citizen for benefit of the government or for use of the government. These three properties, wherever, shall vest in the government of Sikkim. Applicability of central laws. Sikkim is the only state in India where residents, 94%, are exempt from paying income tax due to its unique historical and legal status. Section 10(2)(6) The case of an individual being a Sikkimese. In case of an individual being a Sikkimese, any income which accrues or arises to him from any source in the state of Sikkim or by way of dividend or interest on securities, provided that nothing in this clause shall apply to a Sikkimese woman who on or after the 1st April 2008 marries an individual who is not a Sikkimese. Explanation. For the purposes of this clause, hey, my stenographer has made a mistake. You have the Income Tax Act here. I'll read from the Act. The section from the Act, there are a few omissions. Significance. Following Sikkim's union with India, its political, cultural and social distinctiveness is preserved. I think, yes. The car I came in, I was a little late. I'll give you an On the ground example. He put up a flag and he has a hidden switch. Yours is a very quiet city, wonderful city. There are narrow roads and there are a few cars. This way, that way, going space isn't there. But if he presses the hooter, the guy in front moves aside and lets him pass. This degree of courtesy or giving privilege to authority, it's a privilege. You will not find outside. It was there in West Bengal, in Darjeeling and all that. I have driven up and uphill traffic gets right of way and people used to wave at each other because this courtesy was extended. Now it has become driving fast without blowing the horn. And it's just our courtesies and everything has receded to inside our houses. Only if somebody comes to your house do you offer him a glass of water. What do? You have the kachara in your house which you take and throw on the street. You see, this was not our civilization. But this has happened. It has receded to inside our house. That I am a nice person, you will only be able to find out when you visit me in my house. You bahar jaake aapke aage ghusa maar denge. That's how we become. You see, we are not being able to handle the stress of life. 260, says, incomes not included in total income. In computing the total income of a previous year of any person, any income falling within any of the following clauses shall not be included. And then we come to subsection 26AAA. In case of an individual being a Sikkimese, any income which accrues or arises to him from all these sources are not to be included in the total income. The exemption comes that way. Income tax is a very difficult provision to read. When I was elevated to the bench, I never practiced income tax. When I was elevated to the bench, I came to sit with a senior judge, and the subject was income tax appeals. I sat beside him in the bench and a matter was called and the argument started. Income tax matters generally are assessee versus court. Unfortunate but true. The assessee engages top shot lawyers because that's the guy who's making a lot of profit and doesn't want to pay tax. So you get some big wig from Calcutta bar or Bombay bar or Delhi bar or wherever. When these guys come, they sort of fire away at the court. The advocate for revenue stand up and says, I appear for revenue, bol ke baith jate. He doesn't see anything. So it's assessee versus court. So that guy starts and the matter is heard. And my senior straight away dictates judgment. I'm still finding the provision. Sitting beside. I'm still finding the provision. Now I'll tell you. This is section 10, subsection 26, AAA. That is how to read it. Section 10, subsection 26, AAA. Section 10 is at page 58. Subsection 26AAA is at page 129. It's the same section. So, judges, lawyers, law students, if you can negotiate the Income Tax Act, you're through. So, how do you read the statute? Section 10 says, at page 58, incomes not included in total income. In computing the total income of a previous year of any person, any income falling within any of the following clauses shall not be included. And 26AAA gives what will not be included. That's how you read the section. 58, 129. Have a crack at looking at the Income Tax Act. दिमाग का बत्ती जल जाए. Because it's the fight between the government trying to be your partner in profit and you trying to cook your books to see that you pay less tax. It's really a battle of wits. You have top shot guys, revenue service guys sitting in government who do these things. Every income tax is not a book, it's a journal. Every year it changes. Finance minister will give lecture in the parliament and you will have new income tax law for the this year, the year following. February में भाषण देंगे ना, and it will come from 1st April, the Finance Act. America used to earn a lot of revenue from service. You see, someone is giving service to someone else. इसमें government का तो कोई, there is nothing the government is providing. They made it mandatory that you have to pay service tax. Likewise, another good source of revenue is oil. You tax diesel petrol. Diesel petrol doesn't come under GST. The states have kept it to themselves. The oil company, the dealers, they put petrol in your car and the tax component, they go to the government's office and deposit. Government doesn't have to do anything. पैसा आता है. You drive and government gets money. Look at Income Tax Act. They have to have income tax officers, assessing officers, they have to have vigilance guys. The chaps are not filing income tax return, वो चोरी कर रहा है, black money है, ये है, वो है. The amount of money they spend to recover tax is substantial. Hardly much profit. But still a book like this. And every year it changes. You see, this is, I would say, my senior, when he became a collegium judge, he recommended advocates who were practicing revenue, income tax. The other guys were very angry. Arey, humse aaya. He was sitting with us. And suddenly, the only lawyer is the lawyer who knows income tax and we don't know anything. He didn't recommend us, he's recommending all these income tax lawyers. Because he himself was not an income tax lawyer when he was in the bar. He became a revenue expert. He also became a criminal expert, Justice Girish Gupta. He became a criminal expert also. He took these two subjects to learn. As a judge, you have that opportunity. Because if you are a lawyer, you will study and probably specialize in a branch. Commercial law, arbitration, rent suits, like that, or criminal trial, or bail. You tend to specialize. जिसमें जहाँ से मौके ला रहा है clients, you specialize into that branch. But as a judge, you sit in one place, your service transfer is change of subject. Judges are usually not transferred. They sit in one place. So what is an essential part of service is transfer. Because you should not grow roots. That's the whole idea. You shouldn't grow roots. You shouldn't become too familiar. So if you change a judge's subject, the whole set of lawyers changes. So the judge is sitting in one place, but actually there is a transfer.
Rule against bias.
Absolutely. Absolutely. The face law thing will not work anymore. So as a judge, when one is exposed to different subjects, the bar feeds you the law. They study at night, they light the candle, they do the mehnat and they come and tell you, they read 10 books and show you one passage. You get the benefit of the analysis of law made by the lawyer and that is your input. So it's easier for you to learn many subjects as you go from one subject to the other. So don't confine yourself. Try and, but of course, if you have the time, because work is also very pressing and that takes up most of your time. So Sikkimese people, they got this, whatever their income arises in the state or something from the produce of Sikkim, whatever here, is not included in their income. But my friend who is the Chief Justice has to pay tax because he is not Sikkimese. Then property and applicability of central laws. That's where we are. So this is the Income Tax Act. Then significance. Following Sikkim's union with India, its political, cultural and social distinctiveness is preserved by granting Sikkim authority over land, resources and local administration. Excessive central intervention is avoided. Assures that rights, tradition and customs of native people are upheld. Enabled Sikkim to join the Indian Union in a way that respected its historical background and the people had peace and were secure. These were the objects. I'd like to think that they have been met. Now, central interference. A little digression. The center has authority over forests. The states have authority over what lies beneath. Now, a state discovers that it has minerals, but there is forest standing on top. So you see, administration brings necessary application of law. How to deal with this problem? Parliament will legislate. They have legislated the forest. Then they have legislated Right of Forest Dwellers Act. There is some such act. Those who live off the forest, they have rights. And the states, the constitution gives them the right to have what is beneath the land. So you see, central interference which is talked about here can come in many different ways, and one may not know that it is. So there was application of mine to exclude particularly Sikkim from it because of its unique nature. So before you form an opinion on whether it's a controversy, you have to read the article. Kitna kuch sikhaya aapne about you? Because I had to do this homework. It's good for me because I learned so much about you and how and what is to come, how we want it to be. Now let's move on to the judgments regarding Sikkim. R.C. Podwal versus Union of India, reported in 1994, Supplement Volume 1, SEC 324. This ruling addressed the constitutional legitimacy of special provisions pertaining to reserving seats in Sikkim Legislative Assembly. The facts include that Sikkim was a monarchy under Chogyal rule before it was merged. Native Bhutia-Lepcha communities were concerned about their political representation as a result of the demographic shift brought about by influx of Nepali migrants. 12 seats were reserved for Bhutia-Lepchas and 1 for Buddhist Sanghas in Sikkim Legislative Assembly. The remaining seats were available to all communities. Petitioner contested the reservation, arguing that the religious basis of the reservations violated Article 15 of the Constitution, which forbids discrimination on the basis of caste, religion or race. Article 15 to देखना है यहाँ पर. Let us see article. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Sub-article 1. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. No citizen shall, on grounds only of religion, race, caste, sex, place or birth or any of them, be subject to any disability, liability, restriction or condition with regard to access to shops, public restaurants, hotels and places of public entertainment, or the use of wells, tanks, bathing ghats, groves and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. Then nothing in this article shall prevent the state from making any special provision for women and children. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. These are all reservations. Nothing in this article or in subclause G of clause 1 of article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes insofar as such special provisions relate to their admission to educational institutions including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of article 30. So all other institutions are subject to reservation, but not minority institutions. Minority institutions are like the one I went to, Mount Hermon School in Darjeeling. That's a Christian Methodist Protestant school. Then you have the schools that are the educational institution of the Muslims, madrasas. Then you have all these, this is protected by Article 30, that they can run their own educational institute, the minorities. Sub-article 6, nothing in this article or sub-clause G of clause 1 of article 19 or clause 2 of article 29 shall prevent the state from making any special provision for the advancement of any economically weaker sections of such citizens other than the classes mentioned in clause 4 and 5. Any special provision for the advancement of any economically weaker section of citizens other than the classes mentioned in clauses 4 and 5 insofar as such provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority education, in the same line. And then there is an explanation. For the purposes of this article and article 16, economically weaker sections shall be such as may be notified by the state from time to time on the basis of family, income and other indicators of economic disadvantage. So you get what is called the income certificate. You are familiar, income certificate? People who are below the poverty line, they go and ask the collector or the district magistrate for an income certificate. So that's an administrative exercise. Okay? So we come, there were 3 issues before the court in R.C. Podwal. Whether Parliament can provide reservations while admitting a new state under Article 2. Whether such reservations violate the secular and democratic principles of the Constitution. Whether Judiciary can review the conditions imposed for state admission. Now, Article 2 must also be seen. Article 1 is Bharat. Territory of the Union, Article 1. India, that is Bharat, shall be a union of states. And then there are some other provisions in the article. 2. Admission or establishment of new states. Parliament may by law admit into the Union or establish new states on such terms and conditions as it thinks fit. So, by Constitution Article 2, Parliament is given power to admit or establish new states on such terms and conditions as it thinks fit. That means by legislation. Admission comes in a case like Sikkim. New states happens by reorganization. There was a state, a new state comes into being. Aaya na Jharkhand, Chhattisgarh, Uttarakhand. Prior to that, what happened? Maharashtra, Gujarat, there were Vidarbha and all those things. That came by 371. So reorganization, you have all these bifurcation of states and reorganization. That happens. That Parliament does. So we know now what Section 2 is. These were the 3 questions, A, B, C, relevant to Article 15, 16, 29, 30 and Article 2. The Supreme Court held that while Parliament has wide powers under Article 2 to admit new states, the powers are subject to the basic structure doctrine and judicial review. Parliament may impose special conditions on newly admitted states like Sikkim, but such conditions must not undermine core constitutional institutions. In light of the constitutional principle of equality allowing for reasonable classification based on intelligible differentia, the court concluded by majority opinion that Article 371F of the Constitution did not violate the basic structure. So the answer to the questions, or rather in the controversy, the decision went against appellate. The Supreme Court had to tread very carefully. Here was the Constitution conferring power. Now here again a little digression. You see, the Supreme Court and the High Courts are called constitutional courts. Not so the subordinate court, though it is provided for by a chapter in the Constitution. So a judge generally gets to fly a flag in his vehicle. Constitutional authority. So the Constitution is the repository of all power. Now Supreme Court and High Court generally, basically why they are called the constitutional court is because they have been empowered to grant constitutional remedy. Article 32, if you have a right violated, you can approach the Supreme Court on the original side. Constitutional remedy. Article 136, if you want to appeal from any judgment of any court or tribunal in India, you can petition the Supreme Court. Constitutional remedy. Article 226, the High Court you can approach for a constitutional remedy. Article 227, this court or tribunal is doing wrong, you can go to the High Court, and the High Court can regulate the procedure, being a court in superintendence. So these are constitutional remedies provided to the people from these courts, constitutional courts. But the subordinate judiciary, they are all to provide remedy by statute. Their civil procedure will be by the Civil Procedure Code. Their criminal procedure used to be by the Criminal Procedure Code, and now the BNSS. The kinds of offence, the amount of punishment, the remedies under the Specific Relief Act, Sale of Goods Act, Transfer of Property Act, Contract Act, all statutory. The distinction. Okay? So, on the one side you have the Constitution, the repository of all power. Constitution gives Parliament power to enact. So therefore, a constitutional remedy and a parliamentary act remedy, which stands on a higher pedestal. Therefore, laws made by Parliament become subject to judicial review. Because the Parliament has been conferred power by the Constitution. So the Constitution, what is the Constitution? Interpreted by the Supreme Court to have a basic structure doctrine. So the basic structure doctrine in the beginning article says, fair. It also makes reservation for minorities. It also says reasonable classification, differentiate. Different, what is the word? Intelligence. Intelligible differentiate. So, going into all that, the Supreme Court held the Parliament was competent to legislate 371F. Therefore, if it has caused thereby reservation of seats in the Legislative Assembly, it is intelligible differentia, does not violate the doctrine, basic structure doctrine, therefore upheld. And in that article also you have seen, cannot be challenged in any court, upheld. No other state has this. Okay? Then state of Sikkim versus Surendranath Sharma. In this case, the facts were, after Sikkim became the 22nd state of Union of India, the Directorate of Survey and Settlement in Government of Sikkim created and advertised certain posts. Now, Directorate of Survey and Settlement in Government of Sikkim. Survey and settlement is a huge administrative exercise. The land, the identification, the plots, the record of it, who was there, who is in possession now, is huge. So how many people you need? It's called the Survey and Settlement, Directorate of Survey and Settlement. You're going to do a survey. So at the first instance, you need people to do the job. So there were posts and applications invited for filling up the posts on temporary basis. Respondents before the Supreme Court had applied and got job on temporary basis. They were not locals. As and when the survey work was completed, surplus employees were relieved of their jobs in years 1980, 81 and 82. Some of the surplus employees who were non-locals filed writ petitions in the High Court of Sikkim challenging the government's decision to terminate their services. A learned single judge of the High Court by judgment and order dated 29 February 1984 allowed the writ petitions and quashed the termination orders. State of Sikkim appealed to the Supreme Court. Now I'll come back to this part I've just read, but carrying on for the time being, the Supreme Court set aside the order of the High Court by relying on Article 371 F.K. Subclause K. Clause K. In doing so, the Supreme Court considered that there was in existence the establishment rules. Though such rules in giving preference to locals may appear to offend Article 16, Subarticle 2, since such a provision is permissible by virtue of Article 16, Subarticle 3, and Parliament permits the establishment rules, continuance by special provision of Article 371-K, the 371F Clause K, inserted by amendment in the Constitution, the requirement giving preference to locals cannot be struck down as unconstitutional, and any action based on the provision would not be inconsistent with Part 3 of the Constitution. These were not really temporary jobs. It came to be temporary because they were hired and fired. We had duly applied and got the job. We cannot be thrown out like this. But this is how the Supreme Court dealt with this complex issue, giving primacy to locals to uphold the termination of service, which otherwise is near impossible. So look at the protection Sikkim enjoys. When it decided to merge with the state of India, or the Union of India, its identity was very jealously protected, to this extent, where any person, first of all, there has to be a procedure before you can take away somebody's job. That's in the government service, not private, hire and fire. That's personal service, not enforceable under contract law. Your remedy is in damages. Today you get a job in a private company, good salary, tomorrow you get a pink slip that your services are no longer required. You cannot take your employer to court and say that he must be compelled to give me back my job. This is only in the realm of government jobs. You just can't get him out. Here is the Supreme Court upholding the termination, giving primacy to the identity of the persons who are retained and the persons who are let go because the job was over. And I don't need continued service of so many people. So किसको आप निकाल दिया? The non-locals. See the extent to which the identity is protected. Association of Old Settlers of Sikkim versus Union of India. 2023, SCC Online, Supreme Court 38. ये गलत है, it is not, हाँ correct है. Section 10, 26 AAA, subsection AAA of the Income Tax Act 1961 exempts Sikkimese people from paying income taxes was contested in this case. It was claimed that Indians who were settled in Sikkim prior to its 1975 unification with India were unjustly left out of the definition of Sikkimese. Additionally, Sikkimese women who married non-Sikkimese men after 1st April 2008 were also excluded, whereas no such restriction existed for Sikkimese men marrying non-Sikkimese women. They argued these exclusions went against Articles 14, 15 and 21 of the Indian Constitution. The Supreme Court thoroughly reviewed the constitutional, legal and historical circumstances pertaining to Sikkim inhabitant status, both prior and following the merger in year 1975. It stated that while 95% of Sikkim's population was granted tax exemption under section 1026 AAA, a tiny minority, roughly 1% of the population known as Old Indian settlers, were unjustly left out because their names weren't on a register. According to the court, the goal of section 1026 AAA was to exempt legitimate Sikkim residents from paying taxes, not just those with paperwork in a particular register. It said that term Sikkimese was too limited, lacked any intelligible differential, and did not pass the twin test of classification required by Article 14. Since both groups were residents, it was unfair to discriminate against them, and it had no rational connection to the law's purpose benefiting Sikkim's residents. Furthermore, it was determined that the clause that excluded Sikkimese women who married non-Sikkimese men after 1st April 2008 was discriminatory. Given that a Sikkimese man who married a non-Sikkimese lady was not subject to the same disqualification, the court vehemently denounced this gender-based exclusion. This violated the principles of gender equality, autonomy and dignity, which are safeguarded by Articles 14, 15 and 21, by establishing an unfair double standard based only on marital status and gender. The court further emphasized that arbitrary and irrational classifications, even if created by the legislature, must be overturned. In the end, the court decided that all Indian residents who made Sikkim their permanent home before 26 April 1975 must be considered Sikkimese, regardless whether their names are listed in the 1961 register. Because it was unconstitutional, the clause that excluded Sikkimese women who married outside the group had to be removed. Now, we have a situation where the woman gets married and goes to the matrimonial home. This was basically the underlying thought to exclude Sikkimese women who married non-Sikkimese men. The thing is, this is not about family. It is about paying income tax. A Sikkimese woman having income in Sikkim, why she should be made to pay tax because she married somebody? That's the point. It's not any other thing. It's not a family law. There is no operation of family law here. You have a section in the Income Tax Act which is called clubbing of income. If one partner, spouse has an income, you cannot contrive to show it or part of it as the other spouse's income. It will be clubbed. So a Sikkimese woman marrying a non-Sikkimese man, and if for the purpose of their family they decide to continue to or set up, if the man decides to come and stay in Sikkim with the person he has married, and if the income of the household is with the woman, no clubbing. Clubbing होने से अलग बात है. It's the man who's earning, but he's saying, no, my wife is Sikkimese, I will not pay tax. ये नहीं होगा. The woman has to earn. The man's income shown as woman will be clubbed. Man's income हो जाएगा. Absolutely very wonderful judgment. You understand? It's nothing to do with a girl moving to a man's house. And girls can do it because they can. Men can't. ये हमारा कमी है. It's our drawback that we can't adjust. But you can. And never mind going from one place to the other. The family grows by what the woman brings to the table. बच्चे सीखते हैं जो माँ सिखाता है, not what the father thinks. He really is a non-entity. You ask me. Alright, we'll go to the last case, I think. SICPA India Private Limited and another versus Union of India and others. This was a writ petition here in Sikkim. This company, a manufacturer of security inks in Sikkim, decided to close its operation in January 2019 and subsequent thereto sold all its machineries and assets between April 2019 and March 2020, reversing input tax credit as per GST law. Despite this, petitioner had an unutilized ITC balance, input tax credit, of approximately rupees so much in its electronic ledger. Petitioner applied for refund under section 49(6) of CGST Act 2017, Central Goods and Services Tax Act, which entails that the balance in electronic credit ledger after payment of tax, penalty, fee or in every amount payable may be refunded in accordance with the provisions of section 54 of the CGST Act. Refund was refused by stating that section 54(3) only allows for refunds in two specific circumstances: zero rated supplies or inverted duty structure. It does not cover business closure. Issue before the court was whether the right to claim a refund of unutilized ITC under section 49(6) is confined to the two instances under section 54(3), or whether a registered entity can claim such a refund upon business closure due to absence of an explicit provision. The Sikkim High Court allowed the petition by saying that though section 54(3) specifies only two situations for refund, but it does not expressly prohibit refunds in other scenarios, such as business closure. The court relied on pre-GST precedent of Union of India versus Slovak India Trading Company Private Limited, reported in so and so, available at Manupatro, which granted the refund in absence of any specific statutory provision. Now this is very complex. The Goods and Services Tax Act. There were a lot of taxes, sales tax, entry tax is I think also subsumed, octroi, both sara taxes tha. Value added tax, all these were merged into what is called Goods and Services Tax. Like I was telling you, America, like petrol you go and put in tax, like the service also, a lot of tax comes. India found this out and passed the Finance Act in 1994. Service tax was introduced in India. Finance Act 1994. Uske baad it became developed. When you look at service tax, you will find in any book the Finance Act 1994. It was replaced by GST. Now the central GST and the state GST all have same provisions. Because of constitutional mandate regarding recovery of taxes, central and local taxes, separate acts were necessary. But the Council of Ministers, irrespective of political affiliation, they sit together and determine the rates of tax under GST. So never mind what your minister says here or what my minister says in Bengal. They have all agreed sitting somewhere, and that is why the rate of tax. GST. You go to buy a luxury item, you buy an essential item, 5%. Goods and services tax. ये tax लागू होता है on the goods as well as the component of service. Right. Now when there is a component, now thing is when it's in the realm of goods, you have a secondary manufacturer, or you have a manufacturer who is making a finished product, or a manufacturer, let's take a manufacturer, this kind of a manufacturer was ink. So this ink, that he is a finished product manufacturer, ink. For manufacturing this ink, raw material is necessary. Now, where raw material is necessary, he has to buy the raw material. Now, if he has 5 components of raw material which make up the final product of ink, then he has to have 5 sellers, 5 vendors who will give him these raw materials. 5 vendor आएगा उसके पास. So he is going to buy 5 different products because each of these 5 vendors are selling a distinct product which all put together goes to make ink. So let's take one vendor. For selling the product to the ink manufacturer, he has also made that product, and he has paid some tax on it. So when he sells it to the manufacturer of ink, suppose the vendor A has produced something which is cost 5 rupees, and he pays on that 5 rupees product sales tax that was there 2 rupees. So he sales tax ki jagah it will be GST. He pays 2. So the product cost to the ink manufacturer is 7 rupees, in which there is an input tax of 2 rupees, because it's an input product of his output manufacture. He's already paid 2 rupees tax because his vendor paid it. So he is entitled to that input tax credit. The humble vendor who sells for 5 rupees has paid 2 rupees tax. So he sells it for 7 rupees. So when this guy buys it for 7 rupees, he is entitled to 2 rupees in input tax credit. Because in an input product, he has paid 2 rupees tax. ऐसे करके you accumulate your input tax, and in his ledger he had so much money to his credit. Because every time he sells good, he has to pay. He has paid the tax, but he has this credit. Now he is closing shop, and he asks for refund. I can't utilize the credit. दुकान बंद हो गया. So I want it in terms of money. Taxman doesn't believe in giving you money. Only takes from you. पैसा देना है तो adjustment in next year. No giving back money. So here was a case where how he will take money, he will take credit, he is closing shop. So here is a judgment where the refund was directed in spite of not provided by. You see the concept of the statute. Statute for taxing is a sovereign right. You cannot challenge an act of imposing tax. It's a sovereign right. Article 265. Otherwise, taxation is thievery. I will work, I will earn, why I will give you? That means you are stealing it from me. But Article 265 says, taxes not to be imposed save by authority of law. No tax shall be levied or collected except by authority of law. So the Income Tax Act, the GST Act, these are all authority of law. These are laws. इसके आधार पर I take the tax from you. Otherwise I would have been stealing it from you. So now when I take it from you, I am not in the business of giving it back to you. I have given you the infrastructure. I have made roads so that the lorry can come and deliver the goods. Pay tax. How I will maintain the road? So you see, this is the whole scheme. You have to understand the whole picture. You see the whole picture. So I am not going to comment on this judgment because it may go anywhere. The concept of tax is to take, the state's sovereign right to take. And the citizen's right is to see that in that situation, kitna tax unko dena hai. So indirect taxes are, they come in, the GST. You look at, you read in the papers that this year's collection has been even more. To give 2 slabs. Do away with the 28%. Our finance minister, she is now very happy. Her coffers are full. Okay. You see, there is, if you spread your tax net, because we have population, if you spread your tax net and lower the rate of tax, your ultimate collection is likely to be more. You can't get huge tax collection only from the rich guys because there aren't so many. Kitna money hai? Right na? So, there is a converse side to it also. Now, if you are a Sikkimese person and you are full of merit, or you want to go and become a film star in Bombay, आपका income तो taxed हो जाएगा. Right? So, time to take questions. We have 15 minutes. Yes. Give him the mic.
Good afternoon, sir. So my question is with regard to the clubbing of income. So if I have to see section 64, it says that there will not be clubbing of income of the spouse.
You are judicial officer.
No, sir. I am the assistant professor. I'm the assistant professor of Sikkim National University.
Judicature, right? I was afraid of the students and here the professor. Tell me.
So, sir, section 64 says that income will not be clubbed if the spouse solely earns from his professional and technical expertise. And what if any Sikkimese woman who is earning and that income does not, or that her job does not require any professional or technical expertise? In that situation, sir, section 64 says that it will be clubbed. And at the end of the day, it is also a taxing statute and we cannot interpret it liberally.
No. Taxing statute has to be interpreted very strictly. Because it is taking something that you think is yours. So it has to be constituted strictly. The thing is that Section Income Tax Act, ये मारवाएंगे.
So I have the soft copy in my phone, sir.
Oh, acha. I still haven't got there, so I rely on the book. देखिए तो 64 आधा बुक चला गया. Which is the particular provision you are relying
So
on?
clause 2 provision. Subsection 1, clause 2.
All right. Let's read it for the audience. Income of individual to include income of spouse, minor child, etc. Subsection 1. In computing the total income of any individual, there shall be included all such income as arises directly or indirectly to the spouse of such individual by way of salary, commission, fees or any other form of remuneration, whether in cash or in kind, from a concern in which such individual has a substantial interest. So, if you have a shop, a man has a shop, and a Sikkimese woman is working in it, her salary paid by the man is going to be the man's income.
What
Simply
about
put.
the partnership business by the husband and the wife?
Yes, so that is my
Madam
concern.
Vice Chancellor, I can only take this much.
Supposing the wife is Sikkimese and the husband is non-Sikkimese and they have a partnership. In fact,
Partnership, it becomes income of the partnership. The individual characteristic is lost. Now the profit of the partnership, that which is given to the Sikkimese woman, will be tax free. So coming back to this proviso, I have not yet got to the proviso. Provided that nothing in this clause shall apply in relation to any income arising to the spouse, where the spouse possesses technical or professional qualifications and the income is solely attributable to the application of his or her technical or professional knowledge and experience. Now the husband opens a clinic and he needs doctors. Sikkimese woman, his wife, is the specialized doctor. So she gets a salary for discharging duty or being available in the clinic. That cannot be clubbed to the husband's income. Got it? Any other question? Because her contribution in the clinic is by...
So I have another question.
Yes.
Sir, this question is in reference with the public referendum. So you said that Sikkim joined India with a public referendum, but so with respect to the abrogation of Article 370, when this question was put before the Honorable Apex Court of this country that whether the article should be abrogated, it should be decided by a public referendum, then Supreme Court straight away discarded that. We do not have any specific provision of public referendum, but there are altogether 3 instances of public referendum in India. So what do you think, or what is your take on this, that what is the constitutional validity of public referendum, if there is any?
First of all, have you found any provision which mandates or allows for public referendum? All right, we are beginning to get warm. Constitutional mandate doesn't provide for public referendum. You can choose your representative. We are democratic. So you get a guy who will say your piece in parliament. But by public referendum, ये बात नहीं है. All right. When Sikkimese people had a public referendum, they were not part of India. ठीक है? So far as Article 370 is concerned, it was a temporary provision. What happened on the ground? What was happening? Hari Singh was the Maharaja of Kashmir. He was having a tough time. These guys were coming at him. And Pandit Nehru said, sign the line, dotted line, tab hum kuch karenge. So that's in that kind of a situation it happened. We were not aggressor. We prevented Jammu and Kashmir being taken over because Hari Singh had refused to come to either this side or that side, and being in the geographical position, the British, they wanted to leave behind a mess. What did they say? On basis of religion, country will be formed. Pakistan for Muslims, India for the rest. And there is a third princely state. He chose the princely state option. That will remain a princely state. In that situation, it happened that Kashmir came to be part of India. So a special provision, temporary. So this temporary provision is in the domain of Parliament. Rakhe, na rakhe. It's no longer a question of accession of a state. And that temporary thing went on for very many decades. It became permanent. अरे बंद ना होने से तो परमानेंट ही हो जाता. बंद हुआ उसी लिए. Any other question?
My lord, can I ask another one?
Yes.
This question is with regard to the first session that we had. My lord, you said that there is less constitutional influence in the lower judiciary. So that brings me to ask you the question with respect to Article 32 Clause 3, which talks about that the writ jurisdiction should be extended toward lower judiciary.
Let us have a look at that clause.
Sure, sir.
Clause 3. Talking about fundamental rights. Now, fundamental rights, when there is an allegation of violation of fundamental right, Article 32 enables a citizen to approach the Supreme Court direct. The thing is, for the purpose of enforcing those fundamental rights, so you have now what is clear to you what are fundamental rights. Part 4, fundamental rights. So, the Constitution does give Parliament the power to legislate. So when the subordinate court, if there is legislation, there has not yet been, if there is legislation that the subordinate courts can also issue these writs, that does not elevate them to becoming constitutional courts, because they will be exercising the power under the statute enacted by Parliament. Parliament in its wisdom has not yet thought so. The founding fathers said, you see, enforcement of fundamental right, if you want to give to the subordinate judiciary, you have to have confidence that there is understanding of what is fundamental right. First of all, do we understand what is a right? We generally think right is license. Soch hai, samajh hai. This is for the development of the nation. If you have a rule-based society, why is the Western world developed? If there is a traffic light which goes red, people stop. Here they don't. It makes you wonder, those guys who are driving cars and riding bikes, they have never been to school. They don't know what is the line, where you have to stop. So you see, first you आगे बढ़ना चाहिए ना. It is for you to inculcate these things in your students. Whenever I meet youngsters, I tell them that at least don't stop becoming what we have become. Our rivers are full of garbage. Look at what is happening. You go to, travel is part of education. Travel. Go to any country that is developed. You will step out of the plane and you will think that you come to a different world. The sky is blue. The water is clean. So we also had that. We are not in some other part of the world. They also have hills, they have tunnels, they have roads. We have landslides, we have floods. We are trying to grapple with the situation. We are getting ahead. But we also think right is license. I will do and someone else will clean up after me. ये हमारा अधिकार है. So when one understands the right, तब ना बोलेंगे how to enforce it. Here तो that is why the policeman, he wields the danda. In any developed country, it's other way around. They use guns because people understand, they are intelligent. Here, when yesterday, like I was commenting at night, this boy who drove the car, he's an ace in what he does. He drove so well. The problem is, here in India, we think that getting there first means you're a good driver. That means you're using common space to the detriment of others, which I am regularly doing because this guy has a hooter. VIP culture is not there in the developed world. Nobody has lights and flashes, only the fire brigade and the police. तो वहां तक पहुंचेंगे ना, we have to learn what is a right. उसके बाद तो बोलेंगे enforcement. So parliament has not been. Yes.
That we cannot deliberate upon the constitution and the articles, but I could give an example. For example, whatever freedom is enshrined in Article 14, if I mean, only a remedy in writ lies before the Honorable Supreme Court. However, the implementation by the Parliament probably has been done through bail jurisdiction, through probably the procedural laws, and which can only be enforced by the, which is only exercised by the.
If you are talking about execution, then you are in the realm of warrants.
Lordship, yeah.
Warrant is something different. Because if you are going to execute a direction as an executing court, then you can catch the judgment debtor by his neck.
Yes. If there is a direction, to that effect, but if the Parliament, I mean, as a trial court judge, I feel that I am exercising or I am implementing principles of the Constitution. In one of the ways is through bail applications and through orders in the
Yes, because liberty is something that is enshrined in the Constitution. Fair play is something that is enshrined. It's all there in my note, which I haven't had time to bring forth to you. If you have time, I have gone through these provisions in the Constitution which provides for fair play, and that has percolated down into including the CPC. You have specific provisions regarding issuance of summons. You have specific provisions regarding ex parte hearing. You have specific provisions regarding meeting the claim. Then you have a provision in Order 22 that is, I think, if there is an exception, Rule 4, I think, 4A, Order 22, Rule 4A, which exempts a plaintiff from causing substitution to a deceased defendant who did not file a written statement. Now look at the concept. If the party concerned didn't have a defense, his successor, what defense he can put up? His legal representative, what? So you need not. So that is, in that case, the case will proceed ex parte and result in a decree executable against that unpleaded defendant, or rather legal representative of the deceased defendant. These are all, these things, they emanate from the Constitution itself. You will find it in my book. Your question?
So, good afternoon, Your Lordship. Actually, I was trying to make the same point which our respected Madam just made. But other than that, I have a point to make here. I mean, I just want your opinion on this. So, regarding enforcement of fundamental rights by subordinate courts, my view is...
No, subordinate courts do not encroach fundamental rights.
I mean...
enforcement.
Yes, enforcement.
All right, yes.
So, this is my view, my opinion, and I tend to believe in most cases, enforcement of fundamental rights require the interpretation of fundamental rights, which in a sense is a question of law, which I believe the subordinate courts do not have the power to do that. Is it because of that? Is it because of this reason that the Parliament has been reluctant to advance this provision, this power to the subordinate courts? I just want your opinion on this.
Parliament might think that the high courts are incapable of doing it. So let's not now empower the subordinate. High court भी कुछ नहीं समझता, आराम शराब बकता है. तो माइक दीजिए ना उनको पीछे वाला.
My question is the first previous sessions for Constitution. Is speedy trial is a fundamental right under Article 21?
Speedy trial is a fun. Speedy trial has been included as an interpretation of fundamental right. There is no specific article in the Constitution saying as a fundamental right that any person who is accused must be given a speedy trial. It has been interpreted that a fundamental right or fundamental rights of citizens include right to fair and speedy trial. Understood? Any other question?
Good afternoon, Your Lordship, all the judges, teachers and students. My question is with regard to the independence of judiciary and separation of power.
Independence of judiciary?
Independence of judiciary.
Yes.
Your Lordship, practically what I can see is that the judiciary, be it the high courts or the Supreme Court, they don't have their own, like, for example, the enforcement agency. The decrees and orders are enforced via other agencies that are directly in control of the state. And I kind of wonder, Your Lordship, that how can we say that the judiciary is really independent?
I'm cutting you short, but trying to answer what I've understood your question to be. Enforcement of a decree is in the realm of administration. It is not our business. Execution does not involve adjudication. It is no longer our business. Judiciary is for adjudication. Where adjudication has happened and there has been a judgment on which a decree is drawn up, that decree is to be executed. It goes to the executing court. Executing court को सिर्फ इतना देखना है how to execute it. It will direct issuance of warrant of arrest. Whatever, the administration then has to take those steps in administration to execute the decree. The decree is not right, the judgment is wrong. ये सब प्रश्न उठता नहीं हुआ पर. There is no adjudication. It's administrative work. So therefore the involvement of the court is only to the extent of giving direction to the administration for executing the decree. If we have our own administration, then we will replace them. So judiciary तो executive बन जाएगा. You understand? So execution is not a matter of adjudication. Execution is for the purpose of enforcement, and enforcement is in the administrative domain. So उन लोग they don't know how to do it, so we tell them. उसको गला पकड़ो, उसका property बेच दो. Understand?
Thank you.